Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I am here with my co-host, and today we are tackling one of the most common questions in immigration delay litigation. How long is too long?
This is a question that comes up constantly. Someone has been waiting for a decision on their immigration application. They know they have been waiting a long time, but they want to know whether their wait has crossed the line into unreasonable delay that a federal court would address.
In episodes 1 and 2, we introduced the legal framework for mandamus and APA claims, including the track factors that courts use to evaluate delay. Today, we are going to focus specifically on how courts determine whether a delay is unreasonable.
The short answer is that there is no magic number. There is no rule that says a delay of 18 months is acceptable, but 19 months is not. Courts look at the totality of circumstances, but that does not mean the analysis is unpredictable. There are patterns in how courts evaluate these cases.
Let's explore those patterns. Why is there no specific time limit that defines unreasonable delay?
Because immigration cases vary dramatically in their complexity, their procedural posture, and their context. A straightforward, marriage-based green card application is very different from an EB-5 investor petition involving complex financial transactions. A case requiring routine background checks is different from one flagged for national security review.
So the same length of delay might be reasonable in one case and unreasonable in another.
Exactly. Courts recognize this. A delay of 2 years might be unreasonable for a simple case that should have been decided in 6 months. But a delay of 2 years might be more understandable for a case involving unusual complexity. Context matters.
Does that make it harder for applicants to know when they have a viable claim?
It requires analysis rather than simple math. But the lack of a bright line rule also works in favor of applicants in some ways. The government cannot hide behind a fixed deadline and say that any delay shorter than that deadline is automatically reasonable. Courts look at the actual circumstances.
If there is no fixed rule, what do courts look at first?
One reference point is the agency's own stated processing times. USCIS publishes processing time estimates for different types of applications at different service centers. When an application has been pending far longer than those published estimates, that can be a helpful indicator.
How do courts use those processing times?
Courts sometimes compare the plaintiff's wait time to the agency's stated processing range. If USCIS says a particular form should take 8 to 14 months, and the plaintiff has been waiting 3 years, that disparity may be persuasive. It suggests the case may have fallen outside normal processing.
Can the government argue that published processing times are just estimates?
The government frequently makes that argument, and courts have treated processing times inconsistently. Some courts view them as non-binding and note that they are moving targets that change over time. Others find them persuasive when a case is far outside the agency's own stated range.
So processing times are useful, but not definitive.
Correct. They are a helpful reference point, particularly when the disparity is significant, but they are not statutory deadlines, and courts vary in how much weight they assign to them.
What about cases where Congress has set a specific deadline?
When there is a statutory deadline, the analysis can be more straightforward. If Congress has told the agency to act within a certain time frame, and the agency has exceeded that deadline, courts take that seriously.
What are some examples of statutory deadlines in immigration law?
One example is naturalization. Under 8 U.S.C. Section 1447b, if USCIS fails to make a determination on a naturalization application within 120 days after the examination, the applicant can apply to the federal district court for a hearing on the matter.
What happens when an applicant goes to federal court under that statute?
The district court has options. It can decide the naturalization application itself, conducting what is called de novo review. Or it can remand the case to USCIS with instructions to act within a specified time. Courts vary in which approach they take.
What does examination mean in that context?
Examination is commonly understood to mean the naturalization interview. However, this has been litigated in some jurisdictions. The precise trigger for the 120-day period can be disputed in certain circumstances.
What about EB-5 investor cases?
For the I-829 petition, where EB-5 investors seek to remove conditions on their residence, Congress contemplated a 90-day adjudication period after the interview. However, practice has diverged significantly from that expectation. Interviews are often waived, which makes the trigger for the 90-day clock disputed or absent in many cases. In reality, USCIS takes far longer than 90 days to adjudicate I-829 petitions, regardless of the interview question.
So the statutory framework exists, but the practical reality is different.
Yes, when a statutory deadline clearly applies and has been missed, that is strong evidence of unreasonable delay. But the applicability and trigger of the deadline can themselves be contested.
Are there statutory deadlines for other types of applications?
Most immigration applications do not have hard statutory deadlines. Congress has expressed a general policy in 8 U.S.C. Section 1571B that immigration benefit applications should be processed within 180 days. But courts have generally interpreted that provision as aspirational rather than mandatory. It expresses congressional intent, but does not create an enforceable deadline.
So statutory deadlines are powerful when they clearly apply, but they do not exist for every case type.
Correct. Where there is no clear statutory deadline, courts rely more heavily on the other factors.
How much weight do courts give to the human consequences of delay?
Substantial weight. The third and fifth track factors both address this. The third factor looks at the effect of delay on human health and welfare generally. The fifth factor focuses on the specific interests being prejudiced by the delay. Courts take seriously the real-world harm that applicants experience while waiting.
What types of harm are most significant to courts?
Family separation is one of the most compelling. When a delay keeps spouses apart or separates parents from children, courts recognize the profound human cost. Immigration is fundamentally about families and lives. Delays that prevent families from being together carry significant weight.
What about employment-related harm?
That matters as well. When someone cannot work legally because their employment authorization is delayed, they face financial hardship through no fault of their own. When someone has a job offer contingent on immigration status and the delay causes them to lose that opportunity, courts recognize the concrete harm.
Are there other types of harm courts consider?
Yes, inability to travel, particularly for people who need to visit sick family members or attend important events abroad. Educational disruptions when delays affect student status. Business losses for entrepreneurs and investors. The general inability to plan for the future when immigration status remains uncertain. All of these are interests being prejudiced by delay.
So courts look at delay not as an abstract concept, but in terms of what it actually means for the person waiting.
That is exactly right. The question is not just how long the delay is in absolute terms, but what the delay is costing the applicant in human terms.
What arguments does the government typically make to justify delays?
The government relies primarily on the fourth track factor, which considers the effect of expediting one case on other agency priorities. The argument is that if the court orders USCIS to decide this particular case faster, it will divert resources from other cases and disrupt the agency's queue.
How do courts respond to that argument?
Courts take this argument seriously, and it is often influential. The D.C. Circuit, in the track case itself, acknowledged this consideration, while also cautioning that it cannot be used as a trump card to insulate all agency delay from judicial review. The weight given to this factor varies by circuit and depends heavily on the specific facts of the case.
So it is not automatically decisive either way.
Correct. In some cases, courts have found the queue concern persuasive and declined to order expedited processing. In other cases, courts have found that the other factors outweigh the government's resource concerns. The outcome depends on the totality of circumstances.
What other arguments does the government make?
The government often points to case complexity. If a case involves national security concerns, requires interagency coordination, or presents unusual factual or legal issues, the government may argue that longer processing is justified.
How do courts evaluate complexity arguments?
Courts look for evidence that the case actually is complex, and that the complexity explains the delay. If the government claims the case is complex, but cannot point to specific issues being actively worked on, the argument is less persuasive. A vague invocation of complexity without substance does not excuse indefinite delay.
Does the government ever argue that overall backlogs justify delay in individual cases?
Frequently. The government argues that USCIS is facing high application volumes and limited resources. Courts consider this at a general level, but they also recognize that systemic backlogs do not automatically excuse delay in every individual case. An applicant who has been waiting far longer than others in similar situations may still have a viable claim, even if the agency as a whole is overburdened.
What if an applicant can show that their case is being processed slower than other similar cases?
That can be significant evidence. Courts may look unfavorably on situations where an applicant has been waiting much longer than the normal processing time, while others who filed later have already received decisions. This suggests the case may have fallen through the cracks or been improperly set aside.
How do applicants demonstrate this?
Sometimes the agency's own published processing times make it apparent. If USCIS says a form is taking 12 to 18 months and the applicant has been waiting 36 months, that disparity is notable. In other cases, applicants may have information about others in similar situations who received faster decisions.
Does out-of-order processing affect the government's queue-jumping argument?
It can. The government's main defense under the fourth track factor is that ordering expedition would be unfair to others waiting in line. But if the applicant's case has already been handled out of order, to their detriment, that argument may lose some force. The applicant is not asking to jump the queue. They are asking to be treated the same as others who have already been processed.
Does an applicant need to show that the government acted in bad faith?
No, this is the sixth track factor, and courts have consistently held that bad faith is not required to establish unreasonable delay. An applicant can prevail even if the government's delay was entirely innocent, the result of bureaucratic backlog rather than deliberate obstruction.
So why is bad faith even a factor?
Because if there is evidence of bad faith, it strengthens the case significantly. If an applicant can show that the agency deliberately stalled their case, treated them differently because of national origin or religion, or engaged in any improper conduct, courts take that very seriously.
What might constitute evidence of bad faith?
Patterns of delay affecting particular groups of applicants. Evidence that a case was flagged for extra scrutiny without legitimate justification. Internal agency communications suggesting improper motives. These are difficult to prove, but when such evidence exists, it is powerful.
But the absence of bad faith does not excuse delay.
Correct. The government cannot say, we were not acting in bad faith, therefore the delay is reasonable. That is not how the analysis works. Bad faith is an aggravating factor, not a required element.
Without citing specific statistics, can you describe generally how courts approach delay claims?
Courts have found unreasonable delay in cases involving extended waits, particularly when the wait significantly exceeds normal processing times and causes substantial harm to the applicant. The longer the delay and the greater the disparity from normal processing, the stronger the case tends to be.
Have courts ever found delay unreasonable after shorter periods?
When there is a statutory deadline that has clearly been missed, yes. A delay beyond a 120-day statutory deadline, for example, can be significant. Context matters. The question is always whether the delay is unreasonable given all the circumstances, not whether it exceeds some universal threshold.
So applicants should not assume they need to wait a specific number of years before they have a claim.
Correct. The analysis is fact-specific. An applicant whose case has been pending far longer than the agency's stated processing time, who is suffering significant harm, and whose case does not present unusual complexity may have a viable claim. Each case turns on its own facts.
What should someone consider when evaluating whether their delay might be actionable?
Several things. First, compare the wait time to the agency's published processing times for that form at that service center. If the wait significantly exceeds the stated range, that is worth noting, though courts vary in how much weight they give this factor.
What else?
Second, consider whether there is a statutory deadline that clearly applies. For naturalization cases after the interview, the 120-day provision under Section 1447B may apply. For other categories, determine whether Congress has specified a time frame and whether the trigger for that deadline has occurred.
What about the personal impact?
Third, assess the concrete harm being caused. Is a family separated? Is someone unable to work? Are there financial consequences, health impacts, or other tangible harms? Courts respond to real-world consequences, not just abstract inconvenience.
Anything else?
Fourth, consider whether the delay can be explained by legitimate complexity. If the case involves genuine security concerns or unusual factual issues, that may justify some additional processing time. But if the case is straightforward and there is no apparent reason for the delay, that cuts against the government.
This framework helps applicants think through their situation.
It does. And for anyone uncertain, consulting with an attorney who handles these cases can help evaluate whether the specific facts support a federal court claim.
Let's summarize the key points from this episode.
First, there is no bright-line rule defining unreasonable delay. Courts evaluate the totality of circumstances, including comparison to agency processing times, any applicable statutory deadlines, the human impact of the delay, and whether the case involves legitimate complexity.
Second, the harm caused by delay matters significantly. Family separation, inability to work, financial hardship, and other concrete consequences weigh heavily in the court's analysis. Delay is not judged in a vacuum, but in terms of its real-world impact.
Third, the government's arguments about queue management and agency resources are considered and can be influential, but they do not automatically excuse delay. Outcomes vary by circuit and depend on the specific facts. Applicants who have waited far longer than normal may have viable claims even in the face of general agency backlogs.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.